like you're explaining to me, and like I said, I showed her law school. So, what are the different ways that you advise? And again, we're not giving legal advice, but I'm just curious, like, is it what you do? You break it down and explain to people, here's why you should hold X, Y, and Z, or is that how you?
That's generally at the end of the conversation. The beginning of the conversation is they get the one pager from Escrow that has a chart with different ways that you can hold title. I've seen them say, give recommendations, which kills me because I don't know how they could possibly recommend a way to hold title to any one buyer without actually knowing their story. So when we're,
what do you mean? Give an example.
so I wish I had it in front of me. So most escrow companies, when they open escrow, a buyer will get a buyer's package. And there's a bunch of documents, their escrow instructions. But one of the forms in there, and this is the most important form in there, is they call them vesting instructions. And vesting is what appears after your name when you're identified as the buyer of the property. Mm-hmm. So if it's Rebecca Larson, comma, fill in the blank. If it's Rebecca and Sanjay, comma, fill in the blank. So they give them this worksheet that says, these are the different ways that you can hold title. This is what each of them does in very, very generic terms. And I saw one company that actually made a recommendation saying, this is the preferred method to hold title. What most buyers do is they look at it, they check a box, they send it in, and they don't think about it ever again. But they might have checked the wrong box for their particular situation. So let's say the boyfriend and girlfriend story. They checked the box joint tenants. Well, the boyfriend really wanted his siblings to have his estate. Right. The equity in that home would have been part of his estate, but for him checking the box joint tenants with his girlfriend. Mm. So that's one big thing. So when I'm working with my clients, I'm talking to them about their story. What happened before this transaction? What do they think is going to happen in the future? Because both of those answers sort of put together, what are we going to do now?
Wow. So this is like exactly why I wanted to bring you on board, because I feel like this is stuff that people just don't pay attention to
they don't know to. They don't know that they need to pay attention to it.
And you give such a simple explanation because I think part of and the preferred thing, it bothers me because, this is people giving legal advice and they don't realize that's an unauthorized practice of law because people are going to go with, it's like going, and it's probably a really bad example. I went to a new coffee store and it's like, what's the best one? He or she said, my favorite is X, Y, and Z. Doesn't mean that's the best one. It's just, they said my favorite. However, I'm going to say, well, that's what the store's favorite. The best thing is at the store. And yeah. I think you did a great job of just explaining the risks that we take when we don't understand what we're signing up for. Now, I know you did say a lot of times things don't go wrong, but now like in this situation, a little bit about the case that I'm dealing with right now, the judge was actually going to grant the partition and sell the property outright because he was like, I see all the documentation. I don't see why I need to do anything else. Let's sell the property. Now, the other party started freaking out because they've been living on that property for decades. But guess what? Because it was titled the way it was titled and nobody thought about it, he or she may not have an option anymore.
Right. And one of the other things to think about is you might not know this is an issue until you're dead. And you're dead, so you definitely don't know it's an issue. And now your family has to figure it out.